Thank you. All right, ready to go?
Just a couple things that relate to Teresa Fazio, who I understand will be the next witness after Mr. Nehring concludes today, and to future witnesses. I do want to raise my objections on confrontation and hearsay grounds and see if we can have an understanding that I need not object to each statement throughout this trial, given the extensive pretrial hearings on confrontation and hearsay, and that I've raised those issues, and my understanding is the court has found forfeiture as to both, and that these are not admissible. In this case, the statements of Julie Jensen are admissible over the confrontation and hearsay grounds.
I agree that he has properly summarized the court's decision.
I have found forfeiture under the rules established by the Supreme Court of Wisconsin. And that record is abundantly clear that you have objected.
Just want to make absolutely sure it's preserved. The other thing, as I was looking at Teresa Fazio's testimony from the forfeiture hearing last time, Judge, I would ask that an effort be made that the typical question and answer format be followed. And just one example is a question at page 98, which was, okay, and do you recall when that occurred? And then the answer was 3.5 pages, almost 4 pages long. So I just, for Mr. Fazio and any other witnesses, I would ask that question and answer format be followed. Forfeiture hearing was a little different animal, but I don't want Mr. Fazio to think that she should just continue on.
Well, Your Honor, with respect to all of our witnesses, we ask them to listen carefully to the question and then answer the question to the best of their ability. And Ms. DeFazio is a teacher, and they're accustomed to speaking more than other people, but we cannot control our witnesses beyond that. We ask them to listen carefully to the question and answer the question to the best of their ability.
All right.
We take our witnesses as we find them.
Let's hope for the best. Anything else?
Your Honor.
All right, ask the jury to come in, please.
Mr. Nehring, yesterday, before we broke for the day, you had testified regarding a conversation with Mr. Jensen and his work computer. Could you just refresh our memory as to that conversation?
I think he asked and answered it. Thought we moved on to this subject and he completed the testimony on this issue.
No, he didn't.
You know what? I have to admit, I was responding to some mail I got from Kenosha about another case, and I didn't hear the question, so.
I asked him to recap his testimony regarding the work computer conversation with Mr. Jensen so that the jury will understand where I'm going with the next question.
No, I don't think that's I don't think I want you to do that.
Okay. Had you had conversations with Mr. Jensen? There was an objection. I'm going to get to that question.
Okay.
Did you have any knowledge whether Mr. Jensen knew how to fry or erase the hard drive on a computer?
Mark had talked to me about a previous incident where he did try to do that.
And did he say how he tried to do that or how he thought about doing that?
Yeah, he told me that he had attempted to do it with a large magnet.
Did he indicate whether that would work?
No, we never talked about whether or not it did work.
Okay. How would you describe Mr. Jensen's computer skills?
They were above average. He was also good at, getting help or knowing where to turn for help when he needed it.
Did he have personal computers?
Yes.
How many?
Objection. Just a foundation.
if he knows he can answer?
At any given point in time, I mean, he was always buying and replacing, but he usually had 2 personal computers.
And what was it that you knew that makes you say Mr. Jensen had above average computer knowledge?
I didn't think that I was that lacking, but a lot of times I had problems and I'd turn to Mark for help, and he'd either be able to help me or he could easily get help.
Did he have software that you didn't have?
Yes, he did.
What kind of software?
It was software related to work, various charting programs and analysis programs.
Analysis of what?
Stock movements, the market movements.
The same thing with the trading that relates to stocks?
That's correct.
Did Mark have any other hobbies to your knowledge?
Yeah, they did. They enjoyed. Mark was an avid fly fisherman. He enjoyed doing that in the boat.
And did Mr. Jensen ever talk to you about an affair that Mrs. Jensen had had?
Yes.
And what did he tell you about that affair?
He told me that it occurred with a coworker or a former coworker. He told me about it after the fact.
How did Mr. Jensen feel about that affair?
He was obviously very upset about it, and I think he remained upset about it and distressed over it for as long as I knew him.
Do you know when he first talked to you about the affair?
Yes, I think it was shortly after Mark joined Prudential Beige. I believe it was around 1990, 1991.
And did he continue to talk about the affair throughout the course of the years until 1998?
On and off, it would come up in conversation, yes.
And when it would come up on conversation, what was Mr. Jensen's reaction or demeanor as he discussed it?
As I stated, he was always hurt by it, and so his demeanor reflected that.
Did it ever appear that his feelings changed or diminished?
No.
So even 8 years later, his anger or hurtness had not diminished?
Both of those, correct.
Did he indicate whether he knew this person that Mrs. Jensen had an affair with?
I think he came to know who he was, yes.
And how did he come to know?
I assume it came out in his conversations with Julie when the affair was aired.
And did he ever talk to you about having some ongoing problems with that man that Julie had an affair with?
Yes, he did.
And what did he tell you?
Over the years, it was a number of things. Initially, the problems surrounded Mark's claims that this individual was leaving photographs showing Julie in compromising positions. Mark indicated these photographs would be left on his car at work or at his house up against the garage door, things of that nature. He also related an incident where late at night they heard the dog barking. It appeared something was in the backyard. He said they turned the lights on and that individual was standing in his backyard in the middle of the night.
And do you recall when he said that had happened?
I don't have a specific date, no, but I believe it was prior to 1992.
Okay. Did he ever indicate that he was receiving harassing phone calls?
Yes, we talked about that as well.
And where did he say he was receiving these harassing phone calls?
Well, he indicated to me he believed they were coming from the individual that Julie had the affair with.
But where was this person calling him? Was it at home or at work?
I think in both places it was indicated that he was receiving calls.
Did he ever indicate that he was receiving mail, harassing mail from this person?
I can't remember if it was in the form of an envelope delivered by the U.S. Postal Service or if it was simply an envelope that was left, in a location for Mark to find.
Now, at a brokerage firm, who opens the mail?
The front office always opens all mail.
And why is that?
It must be a compliance issue. They want to know. They keep very close tabs on our communications with clients, communications that are incoming as well as, outgoing.
And so if any harassing mail had come to Mr. Jensen at the office, that would have been opened by who, a secretary?
Leading calls for speculation.
It would have definitely, without exception, have been opened by the front office. Even if an individual sends us a letter, an envelope, a package that says personal, private, confidential, it's still opened. That's the policy.
Okay. And did any of the secretaries that you worked with, that Mr. Jensen also worked with, complain that Mr. Jensen was receiving harassing mail?
Not that I know.
Did any of the secretaries ever indicate that Mr. Jensen was receiving harassing phone calls?
No.
And this policy of opening the mail by the secretaries, was that the same at every firm that both you and Mark Jensen worked at throughout the years?
That's correct.
Was there a point when Mr. Jensen stopped talking about harassing mail and harassing calls?
Yes.
And when was that?
It was a long time ago, and I can't remember exactly when it was. There was a greater frequency of that happening when we were at Prudential Beige, around the 1990, 91, 92 area. Maybe it continued for a little while after that. And then I think I didn't hear a whole lot about it. Then I believe we began hearing again about it in 1998.
In 1998, when you were both in the Racine Stiefel Nicholas office?
Meeting.
Okay.
Well, the witness just gave the year, which is the introductory portion of the question, and then rephrase your question.
I'll rephrase the question. At which office were you working when the talk of harassment by Mr. Jensen began again?
Yeah, it started up again when we were both working at Stiefel Nicholas.
And then at some point, he stopped talking about it?
Yes.
And did that seem to coincide with any events that were occurring in his life?
Yes.
What event?
The blooming or affair with Kelly Labonte.
Now, this affair with Ms. Labonte, how often would Mr. Jensen talk to you about Ms. Labonte?
Objection asked and answered.
Overall,
Please repeat the question.
How often did Mr. Jensen talk to you about his affair with Ms. Labonte?
He talked to me about it a great deal.
He confided in you?
I believe so.
Do you know, based on what Mr. Jensen told you, how often he was seeing Ms. Labonte?
Objection asked and answered.
No, I don't think so.
it's not an identical question. The objection's overruled.
Please repeat the question.
Did Mr. Jensen tell you how often he was seeing Ms. Labonte?
He didn't give me a frequency, a number of times he saw her, but oftentimes I was aware that he was seeing her or going to see her.
And how did you know that?
He would tell me
And what would he say?
that he was going to St. Louis to see Kelly.
He would go to St. Louis. Would he stay overnight?
No, I think a a lot of times he'd leave at 9 or 10 or 11 in the morning, and it was my understanding that that he'd return, late that night or early the following morning.
And did he indicate to you what he was telling Mrs. Jensen about these long nights or these trips?
Yes, he was calling it a business trip.
Did Mr. Jensen ever tell you that Mrs. Jensen found out about his affair with Ms. Labonte?
No.
After Mrs. Jensen died, did he ever tell you that Mrs. Jensen found out about his affair with Ms. Labonte?
No.
Did you ever give Mr. Jensen any advice about starting an affair or what the appropriateness of having an affair?
Yeah, when it was kind of early in the affair, he was kind of torn whether or not to proceed or to cut it off, and he kind of inferred he was looking for advice. Maybe he was using me as a sounding board, and I told him I didn't think it was a good idea. It's difficult with children and things like that.
And how did he react to that?
I think emotionally he had already gone too far. He kind of heard you, but he clearly did not take that advice to heart.
And what exactly did you tell him about the ramifications?
We talked about custody of kids, possibility of one spouse moving away, and things like that.
Did you tell him that it was a difficult position to be in terms of getting a divorce?
Yes. And that was the framework of the difficulty of one spouse getting custody and possibly moving away. It was within the context of a divorce.
Did you ever talk to him, or did he ever talk to you about the financial ramifications, like splitting money and the assets, splitting the assets?
No, I don't believe that was an issue for him.
Why not?
We simply never talked about it.
Okay. Now, at the time that Mr. Jensen was having his affair with Ms. Labonte, he was also talking to you about the condition that Mrs. Jensen was in?
That's correct.
And what exactly was he telling you?
Judge, well, it's fine, I withdraw.
I felt he was trying to create a picture, create an image.
Well, let me just interrupt you for a minute, sir. The question actually inquires about what was said to you by the accused, not what you felt about it.
Okay.
Okay.
He told me that she was very ill, she was depressed, she wouldn't eat. He said specifically that she had lost so much weight, we wouldn't recognize her, I wouldn't recognize her. Things of that nature on an ongoing basis.
Okay. Did he indicate whether she would leave the house?
Yes, I had the impression that she was reluctant to do that.
And how did you react to this information?
I didn't really believe it.
Why not?
Move to strike.
Sustained.
What did you do in response to this information Mr. Jensen was telling you about his wife?
Ask and answer.
Overruled.
I thought it was contrived, and
It's important that you answer about what, for example, was said to you, that what you did was the question, I think.
Okay.
And not what your own feelings were, your judgment on it.
but what I did do was ask my wife to call Julie and take her out to lunch.
And Did it appear after your wife's lunch with Mrs. Jensen that Mr. Jensen's description of his wife was accurate?
Objection.
That incorporates some hearsay, I think.
Are you asking me?
No, I was actually telling you. It was another form of saying the objection is sustained.
Okay. After Mrs. Jensen's death, did you talk to Mr. Jensen about what had happened to Mrs. Jensen and how she died?
Please repeat the question.
Did Mr. Jensen ever talk to you about how his wife died? Or why she died?
Yes.
And what did he say?
Well, he told me that he believed she had died from a drug interaction.
And when do you recall he told you this?
The day after her death when he called.
Did he describe to you how he found Mrs. Jensen?
I asked him who found Mrs. Jensen.
I have an objection for 971-23.
We testified to this.
You talk. Talking about subsection.
In case of state v. Delau.
What?
In case of state v. Delau, DELAO.
What subsection are we talking about?
The
1B?
yes.
Was this something that was conformity with that statute?
Your Honor, I believe Mr. Nehring testified to this at a prior hearing.
Let's have a look. What was the date?
What's the date? I don't have.
August 29.
Your Honor, I'll refer you to page 20, lines 11 through 15.
I don't think that's what the question went to.
That's,
Well, I think that's exactly the question, actually.
Oh, can we have it read back? That's not.
Yes, sir.
That's not what I understood this direction to be going. So that would be. I would agree. That's okay. But
Read back.
Excuse me, and did he describe to you how he found Mrs. Jensen?
well, I read the how to be something I'd never heard about. If this is the subject, then I don't have any objection at all. I guess it's the how is vague, and so I didn't know where we were.
Well, even if it is, I think you've got fair notice that the general subject saw the objections overruled.
you can answer the question.
Please re-ask it.
Did he say how he came across Mrs. Jensen on the day that she died?
Yes, I asked him who actually found Julie, and he told me he had picked up the boys from school, and when he arrived at home, something didn't feel right. And so he asked the boys to remain in the car, and he went in, and so he indicated that he had found Julie.
He had what?
Found Julie deceased.
Did he ever describe this weird feeling that he had?
No.
When Mr. Jensen was talking to you about Mrs. Jensen's condition, did he ever talk to you about helping her relax with a glass of wine, for example?
Yes.
And what did he tell you about that?
That specifically, that he was trying to get her to relax, and one of the ways he was trying to do that was by offering her a glass of wine in the evening.
And what did he say her reaction was to that?
It was always no.
Did he ever tell you that on one occasion she did accept a glass of wine that he offered her?
Yes, he did. He told me about one occasion where she did accept it, and he said she was sitting on the sofa and took a drink, and immediately following the sipping the wine, she fell over sideways.
Did he have any explanation for that?
No.
Now, Mr. Nehring, do you know a Mr. Edward Klug?
Yes.
And how do you know him?
We both work at the same company.
And how long have you worked for the same company?
Mark and I went to work for them in June of '98. Ed Klug would have followed shortly after that, within a month or two or so.
When you say you and Mr. Jensen went to work for them, who are you referring to?
Stiefel Nicholas.
Okay. You didn't work for Mr. Klug, correct?
No.
Okay. And have you had contact with Mr. Klug over the years?
When you say over the years, can you be more specific?
Well, since the time that you both started working together or working for Stiefel Nicholas in 1998, have you had contact with him?
I think in 1998, I did go to St. Louis for a company gathering, and we probably said hello because Stiefel Nicholas was making new inroads in Wisconsin, and we were in Racine, Ed was in Appleton, so I probably said hello, but I didn't have any other contact beyond that.
Have you had contact with him since 1998?
Yes.
More extensive contact?
Yes.
Have you had sufficient contact with Mr. Klug so that you feel you have an opinion as to his character for truthfulness?
Yes.
And what is your
I
opinion?
object. I don't think there is that foundation.
Sustained.
Okay. Can you describe the other contacts you've had over the years with Mr. Klug?
Yes, we had both attended a gathering in Boston, hosted by another company, John Hancock. And I had heard previously that Ed had something to say about, in a conversation with Mark. And so I sought Ed out at that gathering, and to hear him say that.
I'm sorry, to
Hear him repeat what I had heard he said.
What had you heard?
Objection, that's hearsay.
Sustained.
Well, Your Honor, I'm not offering it for the truth of the matter asserted. I mean,
It sounds like you're setting the stage, and maybe I'm missing what's going on here, but it sounds like you're setting the stage for him to render an opinion as to the truthfulness of the accusation.
no,
As
not
opposed
at all.
to his knowledge of the reputation of Mr. Klug in the community for honesty and integrity, or his own personal opinion based upon adequate knowledge.
Again, Mr. Nehring, how times would you say you've spoken to Mr. Kluges from 1998 to 2007?
Maybe once in 1998. I looked him up to talk to him when we went to that conference in 2006. And I contacted him after I shared the information that I had with you prior to the hearing that took place this summer. And then I might have had a few conversations with him over the telephone, very brief conversations with him over the telephone since then. That would have been since this summer.
And have you had business dealings with him?
Never.
Any conversations regarding business with him?
Yes.
And how many times would you say you've had business conversations with him?
Well, when we were in the gathering in Boston, I flew back with Ed, and we had adjoining seats on the plane, so we talked business all the way back.
Now, Mr. Nehring, you referred to having a conversation with Mr. Kluge in Boston. Can you tell me what you remember about that conversation?
Yes. I told Ed that, we talked about Mark's ongoing trial, and I can't recall if I had asked Ed or if he simply offered it up, but we did talk about the fact that Mark told Ed that he was going to try and kill his wife.
And tell me exactly what you said to Mr. Kluge and what he said back to you. To the extent that you remember.
Yeah, I remember very clearly, and I don't remember the conversation leading up to it, but what I do remember very clearly is he stated, he said he was going to kill her. And I asked Ed if he elaborated on that, and he said, well, basically, the theme was Mark was looking for things on the internet, and the basic theme was howtokillyourwife.com.
And when was it that you had this conversation with Mr. Kluge?
That was in the fall of 2006.
Now, what prompted you to ask Mr. Kluge that question?
Objection.
Sustained.
Again, Your Honor, it's not being offered for the truth of...
The objection is not hearsay. The objection is, it doesn't make a difference what his motivation was, does it?
Well, I think it does.
Why?
Well, it seems, I think, a little odd that you would approach someone...
That doesn't have to be explained. The evidence is what the conversation was, not why he did something.
Now, Mr. Nehring, after you had this conversation with Mr. Kluge, when was the first time that you discussed that with anyone from law enforcement or the district attorney's office?
When we were preparing for the hearing last summer.
Do you recall what month that was?
No.
And do you recall what you told us, what you told either law enforcement? Who did you talk to?
About my conversation with Ed?
Yes.
Well, then specifically, I told yourself and the special prosecutor.
And what did you tell us?
That's hearsay, Judge.
Why is it not hearsay?
Just that's the first time you talked about the conversation with us.
Okay.
Yeah.
Okay.
I would just leave it at that.
Okay. I'll withdraw the question. Now, should I go back to? What about his character within the community? At some point, did Mr. Jensen talk to you about an interview that he had with Detective Ratzberg?
Yes.
And do you recall when you had that conversation with him?
It was at the end of the day. I don't recall the specific calendar date.
Well, how close in time to the time of the interview or the day of the interview was it?
It was the very same day.
The very same day?
Judge, I think this does fall under NCLE 123-1B.
Is there 1D?
B.
Oh, B.
Yeah.
Is there compliance on that?
We didn't know about it until this morning.
Oh. That if they didn't know about it till this morning.
I think under the law, it's problematic, and I could have been told.
Why don't you give me? I think that that case was it was a finding that there was imputed knowledge. For a disclosure that had been made almost a month before the trial.
Your
There's
Honor,
a different claim being made here.
I just don't think that it's feasible to discuss or argue this case in front of the jury.
All right. Does Walworth County provide you folks with coffee when you're on your breaks? Sounds great. We're going to keep this one pretty brief, so
One cigarette, maybe.
if you'd like your coffee cooler, don't pour more than half a cup.
Please all rise.
Why don't you give us the historical background, Mr. Jambos?
Well, Your Honor, this is obviously Ms. Gabrielle's witness, but I was in the chambers at the DA's office, the Walworth County DA's office this morning, when Ms. Gabrielle was interviewing Mr. Nehring, and we had not known coming into court that there was going to be an issue raised by the defense counsel about notice regarding suffocation. And I didn't know Ms. Gabrielle was actually going to be asking Mr. Nehring this question this morning before trial started, but she did ask Mr. Nehring about whether or not Mr. Nehring had any conversation with the defendant after the April 1999 interview with Detective Ratzberg. And in fact, Mr. Nehring did have conversation with Mr. Jensen, and Mr. Jensen had related to Mr. Nehring that Detective Ratzberg had expressed suspicion that Julie had been suffocated. And so that's that's the purpose of this conversation. And we have not specifically disclosed, we had not in advance of trial specifically disclosed this particular statement of the defendant to defense counsel, even though we have been diligent in trying to disclose to defense counsel everything about this case in advance of trial, because we had not known about this statement in advance of trial, because nobody had ever asked Mr. Nehring about it. And so I don't have any, one of the reasons I wanted the recess was so that now defense counsel knows. I believe that's a fair approximation of what it is that Mr. Nehring is going to say. It wasn't our effort to in any way withhold this information. I have tried, like I said, repeatedly to provide Mr. Albee and Mr. Glynn with every piece of information that at least as it relates to statements of the defendant that we may be using at trial.
Mr. Albee?
Sorry, just one moment.
Go ahead.
Several things, Judge. And I understand sometimes those things are going to happen, and if I know about them coming into court, even a minute conversation outside, it gives me the opportunity to make an objection, because when we're dealing with defendant's statements, the potential for prejudice is enormously high if something inadmissible comes in, and so I need that notice to be able to object, and I didn't have that, and I'm not really casting any blame for that, but when I get put in that position, I have no idea what he's going to say. Mr. Jensen said, and I have no notice, I'm going to need to register an objection, which I'd prefer not to in front of the jury. And then I think in a case like this, that this testimony is inadmissible. I think sort of the explained relevance is that I've complained about the lack of notice on suffocation. Well, that's a legal issue for the court, not one that the jury is involved in. Second, it's hearsay because Mark is expressing what somebody else told him, which was false. I mean, they're going to get this information in when they present the interview of Detective Ratsburg. Mark is relating, Detective Ratsburg told me that he believed Julie was suffocated. That's hearsay.
No, I don't think so.
And because the defendant's knowledge is irrelevant.
No, well, wait a minute. First of all, I don't think that the declarant statement, which is Lieutenant Ratsburg, I don't think that the state is offering Lieutenant Ratsburg's statement to prove the truth of the matter asserted. It's offering it to show, I gather, some kind of knowledge or acquaintanceship of the accused with the accusation.
Well, not only that, Your Honor, not only that. It's just so that the court is fully aware of the state's theory of it. First of all, it's not hearsay because it's a statement by a party opponent. It's what Mr.
No, he's talking about Lieutenant Ratsburg's statement to the accused.
But he's talking about what Mr. Jensen knew. And what Mr. Jensen said to Mr. Nehring was that he had been confronted with this proposition of suffocation. What the defense, when he was cross-examining Dr. Chambliss, aggressively cross-examining Dr. Chambliss, is that, oh, now suddenly the state has a new theory of how Julie Jensen died. Well, this conversation occurred in April of 1999. And so the fact that Mr. Jensen had been confronted with this statement in April of 1999 rebuts the cross-examination issues that were being raised with Dr. Chambliss. And we're entitled to rebut that by whatever evidence, particularly here it's coming right from the defendant's own mouth, that he had been confronted with the proposition that Julie had been suffocated in April of 1999.
Judge.
Excuse me, but isn't that what I said?
Oh, I don't know.
All right.
Maybe it's the way I
Go
said it.
But Judge, what's my answer to that? Mr. Jensen gets legal counsel in this case, and for 6 years we are told it is not suffocation. We are told, as Mr. Jamboy said yesterday, that he has conceded that Detective Ratsburg was lying. So I mean, do we do all the correspondence?
No, he was lying when he said he knew, didn't he? I think what was attributed to Lieutenant Ratsburg was that the ME had said that it was a suffocation. That's different from saying
that Chambliss had concluded that.
All right, well, that was not true, wasn't it?
That was not true. That was a lie.
So we know that when the states conceded it was untrue, he's right.
What is the relevance of him telling him this? Because
just what I said, the knowledge of the accused of the accusation that was out there, whether or not it was the one which was the target accusation of the state is in terms of cause of death. The defendant's not charged, by the way, with poisoning the decedent. He's charged with killing her.
But Mark Jensen, Mr. Jensen right here, what he knows about what the police think is not relevant unless it would affect something about his testimony or something else. And that's the missing link here.
I don't agree with you.
Secondly, Judge, this court, I thought, had made really clear not to talk to witnesses while they're on the stand.
Wait a minute, that's, no, when they're subject to cross-examination. This witness is still our witness. He's on direct examination. There was no order from this court that we're not permitted to talk to our witnesses.
Well, I think I don't think I had made a general order. I think I made it in a couple of instances, and I think everyone kind of informally agreed to adhere to it, that there was to be no consultation with witnesses in mid-examination, which is what this is. But look, number one, it was not made a formal order. And secondly, if you want me to make it a formal order for the future, I will do so.
Well, now wait.
Just a minute. And third, if there was a violation, it doesn't sound to me, and I'd certainly want to hear more if anyone says there's more to it, but it doesn't sound to me like there was any purposeful or egregious violation. So that's number one.
Well, Your Honor, if the court is contemplating issuing an order that a trial attorney is not permitted to talk to a witness while the witness is on the stand, even when the witness is their own witness. In other words, this witness is not subject to cross-examination yet. He's our witness, and this is supposed to be a pursuit for the truth.
You can sometimes derive a sense of what the other side is up to by listening to the cross-examination questions. But look, I don't want to, look, I have not imposed a general mid-examination order prohibiting interviews. And usually as an alternative to doing so when I'm really pressed on the issue, I just suggest that it be done with both counsel present. And usually that solves the problem. But look, I don't want to get bogged down on this right now. We'll talk about it later if you want to have such an order, and we'll deal with it. I have made it in a couple of instances because I generally do think that it's appropriate. And it's going to be both ways, by the way. If there are defense witnesses and I issue such an order, it'll bind them as well as the state's witnesses. So, but where were we?
And Judge, so my last objection to this is it's improper bolstering of the state's theory. It's some pretense that there is a suffocation theory being forwarded by state's experts at the time.
No.
And
No, it's not.
I think it's a backdoor way to improperly bolster. Well, I understand the court is rejecting it, but I think I need to make that record.
I think the question is whether or not, it centers around whether the accused made statements about Lieutenant Ratzberg having asked him about suffocation as a cause of death. And that does have a legitimate purpose in terms of the defendant's familiarity with the existence of the suspicion, accusation, whatever you want to call it. And as far as the notice, I do tell you, I think it was not proper to go into something which is of this significance without having given Mr. Albee notice of it before we started this morning. So that ought to have been done.
I apologize. It was inadvertent.
Okay, and I can understand that could happen, but just for the future, you should know that something of this importance should be discussed, but I don't see any harm to it, and I don't think you've claimed it, and I don't. There's no evidence that you were in any way harmed because we ended up in the same place anyway. We would have had this discussion an hour ago instead of now.
I agree with that. I would like my objection sustained and then explain to the jury the problem is now solved or something like that, because my objection was proper.
That seems fair.
And which is the reason, Your Honor, that I was requesting a recess.
Which you were absolutely correct in doing. All right, so I'm going.
Are you going to tell that to the jury as well, Your Honor?
I beg your pardon?
Are you going to tell that to the jury as well? That the state was correct in requesting a recess?
I'm going to.
We all want points with the jury, Your Honor.
They lost their points.
What I'm going to tell the jury is that the objection was sustained and that the problem has been resolved. Is that okay?
That would be good. Sure.
Okay, thank you. Would you ask them to come in, please?